Today, we're going to revisit Brexit and try and summarise some of the key points from the EU Trade Cooperation Agreement and just try and summarise what that means for you. Before we begin, by way of introduction, my name is Mark Davison. I'm Head of International Arbitration here based at Mills Reeve in our London office, and today I'm joined by Eric France.
Hi, I'm Eric France. I'm a commercial disputes partner, also based in the firm's London office.
So, after 4 years of discussing Brexit, you would have thought that everything would have been resolved one way or the other within the TCA. And to some extent, a lot has been resolved, but as we'll come on to discuss, there are still some quite major areas which still need to be resolved. Obviously, this is a massive topic, and we could just spend all day discussing this, but we're going to try and focus on 8 areas which impact commercial agreements and what you do on a day-to-day basis, and try and provide some practical points of what you should be doing. Unfortunately, we just haven't got time today to discuss issues as to what impact the agreement has on, say, for the supply of goods and services to the EU. Obviously, the agreement isn't a one-size-fits-all, and there's a different approach to different sectors. But obviously, if you're experiencing a particular issue at the moment, which we don't cover today, and you'd like to speak to one of us about it, then please do let us know, and we'll be more than happy to have a discussion about that. Just before Eric kicks off, we've got a Q&A function, so please feel free to ask questions. I think we've got about 170 at the moment, so we'll try and deal with as many of those questions at the end, and if we're not able to address those, then we'll follow up afterwards. We've had some queries in before. One was about a particular tax issue, which we'll take a look at and follow up separately after the session today.
Okay, thanks, Mark. The first issue is governing law. So this is about what law is going to govern your contract now that the transition period has ended. And by governing law, we mean the country's laws that set the rules for how your contract will be interpreted and define what remedies you're entitled to if the other side breaches the contract. And the good news is that when it comes to determining the governing law, Brexit hasn't had much impact at all. The rules about governing law are set out in an EU treaty called Rome I, and although the UK is no longer bound by that treaty, it has incorporated its substance into English law through UK legislation. So if the parties have made a choice of governing law in the contract, both the English courts and the courts in EU countries will continue to respect the choice that's been made by the parties. The rules in Rome I also deal with where the contract is silent about what the governing law is. And those rules are a bit complicated, but basically, and I'm summarizing here, there are a number of rules for different types of contracts. So for example, in a contract of supply, the governing law is the law where the supplier is based. And those rules where the contract is silent about the governing law will also carry on applying. So in summary, there's no change to the governing law rules as a result of Brexit.
The second issue we're going to look at is about dispute resolution clauses, and principally around jurisdiction and enforcement of when you're dealing with the EU counterparties. So when I'm talking about jurisdiction, what I mean is in what court, country can you bring your contract claim? And then by enforcement, I mean in what country are you going to try and enforce that judgment? Put shortly, as you may have read, it's still a bit of a mess. So as a quick refresher, the old regime was that the UK was part of something called the Brussels recast regime, and that regime still continues to apply to any case that was filed in the EU or UK courts before the 31st of December 2020. So put simply, that means that the EU and UK courts will continue to stay any proceedings which have been brought in breach of a jurisdiction agreement and will allow for enforcement of each other's judgments. But in respect of where we are now, so I think, as we all know, the UK's preferred approach is to join something called the Lugano Convention. And basically, Lugano is a convention which governs jurisdiction and enforcement of judgments between EU and what are termed EFTA, so European Free Trade Association states, which include Switzerland, Iceland, and Norway. It operates similar to the way that the original Brussels regime did before it was recast in 2012, and it would certainly be ideal for the UK if we were able to join Lugano. But I think, as we all know, we're not quite there yet. So the UK submitted its application to accede to Lugano back in April 2020. The EFTA states have agreed, but the EU hasn't, and we just don't know when that will be resolved. So, in respect of where we are now, so basically, we're going to have to rely on something called the Hague Convention 2005. And the UK joined Hague as of the 1st of January 2021. The EU didn't have the right to block that. The Hague Convention is better than nothing, but there's 2 points I'd make. First, it only provides the ability to enforce agreements where there is an exclusive jurisdiction clause agreed by the parties. So what I mean by that is that you've actually agreed within your dispute resolution clause that the English or, say, the French courts have got exclusive jurisdiction to hear that claim. And second, actually, there is a debate as to when it came into effect. So there's a debate as to when it came into effect in respect of the agreements that have been entered into with European counterparties. So the way I understand it is the UK's position is that the Hague complies to any agreement that was entered into post October 2015, when the EU joined the Hague Convention, and the UK was a party to the Hague through its membership of the EU. But the EU has said that it doesn't agree with that, and that it will only actually operate from the 1st of January 2021, when the UK joined in its own right. And that's going to have to be resolved one way or the other going forward. If Hague doesn't apply to the agreement that you have with your European counterparty, then you're going to have to look at the local laws of the state, of the EU member state, where you're going to try and enforce your judgments to see how you'll be able to enforce any UK judgment. That should be possible, but it's just going to add that extra layer of cost and time. For those of you that use arbitration clauses, the good news is that Brexit doesn't affect arbitration. Both the UK and the EU are parties to something called the New York Convention, which allows for the reciprocal enforcement of arbitration awards across, I think it's over 160 states across the world.
Okay, next up, territorial references to the EU in contracts and whether or not they'll be interpreted as including the UK. Agreements such as licenses or agency agreements often tend to make reference to territories in which one of the parties or even both of them are permitted to exploit the opportunities under that agreement. But the question is whether agreements that define territory by reference to the EU or the EEA will be interpreted as including the UK. And the answer is it's likely to depend on when the agreements were entered into. So when interpreting agreements entered into before 31 January 2020, the court may well start with the assumption that the parties did intend for the UK to be included in the reference to the EU or the EEA. But that's likely to be different in respect of contracts that were entered into post 31 January 2020, when the UK left the European Union, and certainly post 1 January 2021, after the transition period ended. But in the end, it's going to be a question of interpretation as to what the parties intended when they referred in the contract to the EU. So in order to make sure you don't fall between the cracks on this, you may want to review your key contracts for references to the EU or EEA now and make amendments to the contract as appropriate to ensure it covers the UK if that's what you intended. Next, references to EU law. Many commercial agreements will contain references to EU law, and this may cause difficulties now that the transition period is over. If you have a contract which contains a promise to abide by a particular EU law, you may want to consider whether you want to continue to agree in the contract to be bound by that law. In working that out, you might want to consider whether it's an EU law which is covered under the UK retained EU law regime. And what I mean by the retained EU law is that the UK has enacted effectively a whole new body of law called retained EU law, which incorporates certain EU law into UK law. And retained law will continue to follow previous Court of Justice of the European Union jurisprudence and case law, but the UK Court of Appeal and certain other UK courts will have the freedom to depart from that jurisprudence albeit that they're supposed to do so sparingly. But if, on the other hand, the EU law that you've referred to in your contract is a new piece of EU legislation, or it's a piece of EU law that is not covered under the retained EU law regime, then you might want to consider whether you still want to agree in your contract to be bound by that law, because effectively what you'll be doing is agreeing to be bound by foreign law as interpreted by foreign judges. So going forward, it's a good idea to deal with these potential issues before they arise and consider amending agreements where you need to.
So the next point we're going to discuss is data protection and GDPR. In short, there isn't a significant change at the moment, but that might change, as I'll come on to. Obviously, again, this is a complex area and we could do more than an hour on this subject alone, but I'll try to keep it swift. But if you're dealing with any sort of data protection issues at the moment, or you have any questions about this and want to speak to one of our data protection specialists, then we'd be more than happy to introduce you to them. I'm going to focus on 2 points, processing data and then data transfers. So in respect of data processing, effectively not much has changed. Effectively, the position is now there's 2 regimes rather than 1. So if you're processing data of a UK subject, the new UK GDPR will apply, which is effectively EU GDPR with some minor amendments. And if you're processing data of an EU subject, then EU GDPR continues to be relevant, as EU GDPR has extraterritorial effect. In respect of international data transfers between the UK and the EU, again, hopefully there's not going to be any substantive change, but it all hinges on something called the adequacy decision and whether the EU gives that to the UK. So previously, under EU GDPR, transfers of personal data to and from the UK and the EU were allowed, and parties didn't have to have any further safeguards, because effectively the UK and the EU, and obviously the bodies that were operating in the UK and the EU, were subject of EU GDPR. But as of the 1st of January, the UK has become what is termed a third country for the purpose of EU GDPR. And so in respect to transfers from the UK to the EU, the UK government has made clear that it's going to permit data transfers until at least 2024 under its current UK GDPR regime. But in respect to transfers from the EU to the UK, basically what the TCA has done is it's extended the transitional period for 4 months. So you'll still be allowed to transfer data from the EU to the UK without further protections. And the reason for that bridging period effectively is to give the EU some additional time to issue its adequacy decision for the UK. And the EU has stated that it expects to make that one way or the other in the next coming weeks. There is a slight concern that the UK's security surveillance legislation may affect the UK's application, especially in light of a recent CJ EU decision in something called Schrems 2, which is about the US Privacy Shield. But I think we're all hoping in the market that the adequacy decision will come. But if the EU doesn't give the adequacy decision, parties are going to have to make sure that there is an alternative transfer mechanism in place with their EU counterparts to allow them to transfer data to UK entities. And so what EU GDPR does is it allows data transfers in certain purposes. And one of them is if the parties adopt something called standard contractual clauses. And the UK government's guidance was certainly that from 1st of January 2021, parties should have ensured that they had alternative transfer mechanisms, such as standard contractual clauses, in place with their EU counterparts to ensure that you can keep the personal data, personal transfer of data from the EU flowing. I've put a reference there on the slide there to the ICO website, which provides some useful guidance on standard contractual clauses. So if this is an issue that you're facing at the moment, then it's well worth having a look on that website.
Okay, Brexit as a possible ground for termination. Brexit's having an effect on the profitability of a lot of contracts, and things like customs paperwork and effects that we've seen on the labour market may be causing financial hardship for one or other of the parties to a contract. and inevitably that may increase the motivations of people to try to get out of performing contracts and exit their arrangements. However, the starting point under English law is that the courts will hold the parties to their bargain, even if that bargain turns out to be a bad one as a result of something unexpected happening. And there are only limited exceptions to that principle, such as where you can argue that a force majeure or termination clause applies, or if the contract has been frustrated because it's become effectively impossible to perform. So if you want to get out of a contract and there's something specific and a force majeure or termination clause about the UK leaving the European Union, then obviously that may well help. But we think it's unlikely that the courts will accept that Brexit amounts to a frustrating event for the purposes of the common law frustration doctrine. And so far as we're aware, there's only been one case where someone's tried to argue that and it failed. The case was Canary Wharf Limited and European Medicines Agency, where the Medicines Agency argued that Brexit meant it should be able to get out of a 25-year lease that it had on its offices in Canary Wharf. But the court didn't accept that Brexit was a frustrating event, and we think that case is actually likely to serve as a bit of a deterrent to other people trying to argue the same sort of thing.
Really quickly on 2P and employment, there isn't any change regarding 2P, which is probably most relevant to those of you that deal with outsourcing contracts or are looking to acquire businesses or certain accounts from clients. There remains a chance that the UK government may use Brexit as an opportunity to tweak 2P in order to make it a bit more business friendly, but we'll just need to watch that space. The way I understand it, obviously Eric and I aren't employment specialists, but we have employment specialists within the firm, but employment law isn't likely to change dramatically as a result of Brexit, as one of the provisions within the TCA was that both the UK and the EU wouldn't derogate employment rights in order to maintain that there's a level playing field between EU member states and the UK. Very finally there, just on the screen. So I just want to touch on a practical issue for those of you that are in-house lawyers and deal with EU subsidiaries or connected businesses. So first, unless you're qualified and registered to practice in an EU state, obviously you're no longer authorised to advise on EU law, save to the extent that it's about retained EU law as it applies in the UK, which Eric touched on earlier. At the moment, you can still provide English legal advice to EU entities and travel to perform that function. Obviously, we can't travel at the moment because of COVID, but we'll just need to keep an eye on just to see whether any member states seek to try and impose any restrictions or registration requirements in respect of travel going forward. The next sort of point that I sort of put there about privilege is just that if you are advising EU subsidiaries, just take care just to make sure that privilege is maintained. I mean, obviously, if you're advising on English law, which would need to be determined by the English courts, then you should be okay. But if you're not, and it's a matter of a member state law that you're sort of advising on, or EU law, obviously, then just check whether actually the advice that you're giving is covered by EU legal privilege and privilege within that local jurisdiction. And so it's well worth checking locally if that is the case. What I have seen is that people have structured their advice so that there is an authorised EU lawyer involved. They're effectively supervising and approving the work in order to try and maintain privilege. I mean, in reality, the impact's likely to be minimal because if you end up in court litigation in an EU member state, most civil law jurisdictions don't have the same disclosure regimes that we have in the UK, where it's often difficult to try and get a party to disclose adverse documents. Effectively, the way that those regimes work is that you disclose documents that you want to rely upon, and it can be quite difficult for the other side to force you to disclose up the adverse documents. Just in respect of advice from a lawyer in the EU to a company involved in proceedings here in the UK, it's likely that the decision there in Tatneft will apply, which held that advice from a foreign in-house lawyer will be privileged, but you'll just still need to show that the dominant purpose was to give advice in order to ensure that privilege is maintained. As part of this series, if you'd like us to give a quick refresher on privilege, then please do let us know.
Okay, just some more practical tips. Again, there isn't a one-size-fits-all approach to what you should be doing now if your business is being impacted by Brexit, but hopefully the following tips might help you a little bit. I appreciate that for many of you, you will have already taken some of these steps anyway. In respect of existing contracts, you may want to consider doing an audit of your contracts. Now, that may not be practical to go through every single contract, but you might want to take a look at perhaps 5 or 10 of your most key contracts and start from there. And when you're looking at your contracts, look to see if there are any obligations which Brexit may have impacted. For example, if it's a supply contract, check out that there are provisions that deal with the requirements for rules of origin, and check that those requirements are being met so that any goods are supplied to the European Union can be traded on a zero tariff basis. Check that there are provisions that you and your counterparties will comply with the new regimes that are being put in place so new issues don't emerge later on. So, for example, check the terms of any supply agreements or logistics and warehousing agreements to check who's responsible for making the newly required customs declarations, because clarity on that point in particular is going to be crucial. You may also want to factor in some of the points that we've discussed earlier, such as whether the dispute resolution clause in the contract will provide you with the comfort that you need that you're going to be able to enforce a court judgment against an EU counterparty if you need to. You should check whether or not the territorial references to the UK are still appropriate. You should also take a look at how the contract deals with the transfer of data between the UK and the European Union, particularly if there is no adequacy decision, as Mark was describing. So if you do need to renegotiate your contracts, take care when discussing them with your counterparty. And by that I mean, take care not to say anything or refuse to do anything that could be taken to be a breach by you of the contract, and be careful not to say anything that could be taken to be a waiver by you of your rights under the contract, or some statement by you that could be interpreted as you agreeing to an amendment to the contract if that's not what you intend to do. In respect of new contracts, again, you may want to update any precedent documents that you have, and make sure that some of the issues that we've discussed have been covered off. And if you'd like to discuss any of your contracts with us further, then Mark and I are here to help.
Okay, so in respect to questions, one of the ones that we had before the session was about retained EU law and how about you go and find that. And it's a really good question. And again, we could probably spend an hour on that alone. Basically, when the UK government put in its legislation for retained EU law, what hopefully they didn't do was just create a specific list of what was retained and what was not. And so there isn't that list for us to refer to. So basically, it's going to be a matter of statutory interpretation. Basically, what retained EU law was designed to do was to create a snapshot of what EU law was as at the 31st of December 2020. And so in order to work it out, you're going to have to look at things such as whether the EU law in question had direct effect, and then how it's been dealt with in the Brexit statutory instruments dealing with it. And then also you're going to have a look at whether there are any judgments have been made on the topic. And then actually we're also going to have to keep an eye on court judgments going forward to see how it's been interpreted and whether that makes any difference. But if there are specific issues that you're dealing with at the moment which are impacted by this new retained EU law, then I would advise that you seek specialist advice. And obviously Eric and I are happy to try and help if we're able to. One of the questions that we've got there is about ECHR. So about whether the European Convention on Human Rights still applies. That's what I assume that question means. So put simply, it does. So I think we all heard that the UK was talking about leaving ECHR. but it's certainly very hardwired within the TCA itself. So, I mean, I suspect if the UK tried to apply to leave ECHR, that would effectively mean that the TCA falls away. One of the questions that we've got here is about getting UK qualifications recognised in the EU, and is there a mechanism for that to happen? There's about 5 or 6 pages of the TCA itself, so it's about 1,200 pages, the TCA, and there's about 6 pages that deals with legal services, which, given that quite key sectors such as the financial services industry was just not discussed at all in the TCA, is probably sort of bit of an honour for legal services industry. I don't think that there is a specific mechanism yet for getting UK qualifications registered in the EU, because I know it's a huge problem at the moment, say for accountants as well, as to how they're going to get recognised when they're providing accountancy services to EU-based businesses. Obviously, with the Big Four here in the UK, that's quite a big issue for them. But what I'll do is I'll look into that and try and follow up afterwards with the person that's asked that question. I think we're coming up to past. Shall we maybe call it there? I think we're a bit longer than the 15-20 minutes we usually are, Eric.
Sure, I can see that a couple of people there have requested a bit of a refresher on privilege, and we're pleased to hear that, because we're planning to cover that in a couple of weeks' time, so a few weeks' time. So we'll be happy to oblige. And if we didn't get to your question today, then we can follow up with you after this webinar. So we've got your details. We'll be in touch after the webinar.
Perfect. Well, I just want to say thank you very much for everybody that's attended today. I hope you found that useful. Just at the end of this, there should just be a pop-up just with a couple of questions, which we'd be grateful if you could answer. And in particular, as this is the first contract conversation that we've held in 2021, if there is any particular topics, as well as privilege, that you'd like us to cover within this series, then please do let us know. In the meantime, thank you very much and have a great afternoon. Thank you.
Thank you.